SJC-10459, Commonwealth versus LeBlanc.
Good morning, Ms. Clubb.
Good morning. I'd like to begin this morning by discussing what is labeled as issue number 2 in the defendant's brief. Deborah Krupp on behalf of Gary LeBlanc. And that is the question as to whether or not there was sufficient evidence in order to give an instruction in this case on rape, and then whether or not the instruction that was given itself was proper. I'd like to point out a few critical facts. There's no dispute about these facts, but they don't happen to be included in the statement of facts in the Commonwealth's brief. The first is that the complainant, during the time that the only time when there was any sexual activity between these two people, voluntarily performed oral sex on the defendant.
Is there evidence that it was voluntary?
Yes, she states in her testimony that she did it freely and voluntarily.
Okay.
Now, going back to that point, I went back to the transcript on that. As far as I could tell, it was 2 lines in the cross-examination. Is there anything else in the testimony about that?
No, there's not. I would point out to Your Honor that the Commonwealth did not bother to elicit that testimony on direct examination. And although the complainant went through a pretty detailed discussion of what acts the defendant and she engaged in, what she skipped over was the fact that she had performed oral sex on him. And the reason that it came out by cross-examination is because the defendant knew about it because she had spoken about it at the grand jury. But again, there was no redirect. There was never the state of the evidence is that she testified that she freely and voluntarily performed oral sex on him.
There was no other evidence that would constitute rape? Is that what you're saying?
No, there was.
That was not the point that I was making.
Oh.
I mean, I guess maybe what you're getting at is there any question about any force anywhere in the case at all? There is no question of force anywhere in the case at all. The Commonwealth tried the case on the theory that she was incapable of consenting. There never was a suggestion of any force of, any behavior at all.
But there were other acts that constituted
Rape.
Yes, and in fact, the Commonwealth didn't
then
rely
what does it
upon
matter?
this act as constituting rape. What they relied upon is, I think there was evidence of digital penetration and there was evidence of oral sex performed by the defendant on the
That's what my question
complainant.
is. So why does it matter whether she also testified to this oral rape or not?
The reason that it matters is because it goes to whether or not she was incapable of consenting.
So, but doesn't that cut both ways? If we conclude that she was incapable of consenting to the other acts, is there a timing issue here that there was? So it's all in the same period.
This all happens at the same time. There is no evidence. It would be pure speculation to decide that the point where she freely and voluntarily performed oral sex on him was either before, during, in the middle, or at the end of the sexual encounter.
So you're saying if she was capable of consenting to oral sex, she was capable of consenting to sex?
That's correct. And there are 2 parts to that. One is somebody who is actively participating in a sexual encounter is, she clearly made a decision. She made a decision, I want to perform oral sex on him. She does that. That certainly seems to be an indication that she's capable of making a decision.
Why would it not be, though, a jury question? I mean, why does that necessarily, as a matter of law, say that it's insufficient for the instruction?
Well, because I think, Your Honor, what this court said in Blanche is that an instruction concerning the capacity to consent should be given in any case where the evidence would support a finding that because of the consumption of drugs or alcohol, the complainant was so impaired as to be incapable of consenting to intercourse. And it seems to me that when you have undisputed evidence that the complainant was a willful and active participant in the sexual encounter, that you do not have evidence from which a jury could determine that she was so impaired that she was incapable of consenting. That's really the defendant's point of view.
There's so much evidence, it seems to me, of ingesting of drugs and alcohol that anybody could reasonably infer that she was incapable of consenting, and somebody under the influence of that much substance, those many substances could go in and out of being able to consent.
Well, there are
sort of
two
in and out
responses.
of a haze of being conscious and not and semi-conscious, and why couldn't the jury decide that that's what happened?
Well, first of all, a couple of points. First of all, Your Honor, again, there's no evidence that that would distinguish the time that she was performing oral sex on him from the time when he's performing oral sex on her.
Well,
I mean,
obviously, okay.
I mean, this is all one encounter. It's not like she says this goes on, you know, for 2 hours and this happened at the beginning and something else happened at the end. Two, of course, there is a lot of evidence that she ingested, you know, that she had alcohol and that she used cocaine. But the fact that somebody is impaired in some fashion or is intoxicated in some fashion is not enough to show that they're incapacitated. And I think you do need to look at the other evidence. And so what happens here? What happens here is, you know, there's a lot of drinking and use of drugs long before this incident.
There's a lot of evidence from her father, from the police, that she's just totally out of it.
But that evidence doesn't actually match what happens because I don't want to cut you off.
No.
Okay, I'll just answer this
I
question
shouldn't
first.
cut you off. Sorry. You go ahead. You go ahead.
So first of all, you know, there's this long period. She goes to the Super Bowl party. She goes to her aunt's. Then she decides to go to his house. She decides to use alcohol and drugs when she gets to his house. She spends the whole night there. You know, there's no sexual encounter. There's no sexual talk, nothing at all. She gets up in the morning and she goes to school. Now, one might say, based on what you were just suggesting, Justice Cowan, that, well, she'd had all these drugs and alcohol, so, you know, of course there was evidence that she was incapacitated. But in fact, that's not what the evidence is. She gets in her car, she drives home, she wakes up her boyfriend. He doesn't see any problem. He, you know, drives her to school. She goes to school.
Wait. But didn't she decide not to go to class because she was under the influence?
Well, first of all, she goes to school and she spends 15 minutes sitting in this guidance counselor's office, right? And again, nobody apparently notices anything, and certainly she's not in a condition where we would say she was incapable of making decisions at that point. She does decide to leave. She decides to go back to Mr. LeBlanc's house.
She decides to leave because she didn't want to go to class because she knew she was under the...
And also, well, what she testified to was she wanted to go back to Mr. LeBlanc's because she wanted to drink more and she wanted to use more cocaine. I mean, she also says that.
I thought she also said she didn't want her guidance counselor to see her in that state.
I think she says she doesn't, right, she does say that. But again, she's not at a state where any of our prior cases would say that she was incapacitated.
But that's at 3 o'clock.
No, this is in the morning.
Okay,
This
that's
is
in the morning.
This is it. You know, she leaves his house at 6 a.m. She drives herself home. She sees the boyfriend. She gets changed or whatever. She goes off to school. She stays there for 15 minutes. She decides she doesn't want to see the guidance counselor or her parents. She also wants to go and do more drinking and drugs. So she calls Mr. LeBlanc and says, "Can I come over?" "Well, yes, you can come over." She gets a ride there. The person who's driving her, you know, she acknowledges that, you know, once the complainant says she's messed up, well, she looks kind of messed up, but, you know, she's getting in and out of the car without any problem. She's having conversations. She's telling her where she wants to go. She spends another hour, apparently, at Mr. LeBlanc. She says she's got to go back to school because she needs to attend her math class.
But you here, I mean, defense counsel argued in closing that she admitted that she had voluntarily done this thing and focused the jury's attention on precisely what you're focusing our attention on. And wasn't it a question of fact as to what she really meant when she said, "Yeah, I did it voluntarily"? I mean, this is
No, I don't think that was a question of fact because there was no other evidence. The only evidence on the point.
The meaning of what she did when she said, "I did it voluntarily," her meaning of those words is a question of fact. I mean, you got an 18-year-old kid with exercising bad judgment. She can, you know, perform certain acts mechanically and go through certain kinds of motions. And a jury could look at it that way.
Well, my answer to that, Your Honor, is that
nobody forced her. In other words, her sense of voluntary meant nobody pinned her hands behind her back and made her subject to
I don't think there was anything even close to any sort of suggestion that, I mean, there was no pinning at all.
No.
I
All I'm
understand
saying
you're not
is-
saying that, Your Honor, but when I'm trying, I guess my point is, if you look at all of the cases in which we have permitted an instruction for incapacity consent, none of those cases involve a situation where the complainant acknowledges that she freely and voluntarily actively participated in the sexual encounter. There are all cases in which the complainant didn't do that. Now, occasionally the defendant alleges it, but the complainant never
The
acknowledges
facts of
it.
this case are a lot like the Blaish case. I mean, the medical records here are not unlike the cases, the Blaish case, or Blash, however you pronounce it. You know, the medical records in that case, the nurse said that she was oriented to time and place. Same thing here.
Well, that's correct. Of course, I'd point out in the Blotch case, there was expert testimony about her level of intoxication. I'd like to get back to a couple of the go ahead.
Well, I guess my question is, when you look at all of the cases, maybe there's not one exactly on point, but and I haven't read them all recently, but my memory of them is that there's a pretty wide range of evidence which has been the basis on which that instruction has been given. So that's one point. I mean, I guess I don't see them as confined, even though, as you say in your brief, it may be that the complainant hasn't testified the way this complainant did about I voluntarily performed oral sex. Nonetheless, I think that the level of intoxication isn't so much greater than some of the evidence in this case. That's number one. Number two, with that statement, why is it that the jury couldn't look at all of the evidence and disbelieve that? I mean, they're not bound to accept her saying, I voluntarily did this, right?
Well, there is no, there's no other evidence. I mean, of course, the jury's not bound to accept
there's evidence of the
anything
way
that a
of-
witness says, but there's no reason offered ever as to why this is not accurate. That there's no indication in any way, shape, or
Well,
form.
there's one indication that that at least, I don't know whether it was argued because I haven't looked at it, but it appears that what triggers the whole criminal investigation is not the victim.
Well, that's correct. That would be
So
her.
we have a victim, we now say, who doesn't present as the classic victim. The outrage comes not from the victim.
No, and I would point out with respect to, of course, yes, there is this evidence from her father that he says she was zombie-like and a robot. But, I think that there's also evidence that when her friends arrive at the door, she hears them, she responds naturally immediately to them. She doesn't come out, but there's no indication she can't come out. She just says, I'm coming. And they eventually go in. She, can get down to the car. Mostly she's just mad at them and keeps, she doesn't tell them about what happened. But within an hour, she's at the police station talking to this police officer. And though her father describes her as a zombie, we know that she wasn't a zombie, 45 minutes later because she tells the police officer virtually everything that happened.
He says she's highly intoxicated.
He says that she's intoxicated. He does say she's intoxicated, but there's a difference between, as this court has consistently pointed out, between being intoxicated and being incapacitated. And,
Right.
And
Just by way of one fact, when her friends came to get her, wasn't there testimony that she was unable to talk and that she was doing something with her mouth, but
there was testimony that she was doing something with her mouth. There was no testimony that she couldn't talk. The testimony was that when they came to the door and knocked on the door and said, come with us, she said, I'm coming. She doesn't come out. They knock again. She says, I'm coming. She doesn't come. And so they decide to go inside and get her. They do have a conversation with her in the car, although her end of the conversation is mostly just being mad at them.
Ms. Clapp, let me ask you this. Footnote 5 of the appeals court's decision. Okay, do you have it in front of you?
I will in just a minute because I know it's in the brief.
Well, it's on page somewhere liquid appended.
I've got it, Your Honor.
Okay. Footnote 5, it's at the top of page 56 of your brief. Second paragraph. Okay. The fact that she performed oral sex on the defendant does not negate the other evidence introduced by the Commonwealth. Okay. Why is that an incorrect statement of the law?
Because I think that the bottom line is, and actually the court sort of alludes to this in the Blotch decision where you recognize that in all cases decided after that decision that the Commonwealth also has to establish the defendant knew or should have known that the person was incapacitated. And it definitely goes to that issue. And I think it just seems to me that when I read all of the cases, and we're talking about whether or not somebody is so impaired as to be unable to make a decision, if somebody voluntarily makes a decision to engage in sex, they've made a decision. They're not incapable of making a decision. I guess that's my response. I notice I have almost no time left, and I realize I have not gotten to the drugging for sex at all, which I'd like to at least discuss for a minute. I guess I would ask if the court has any questions about that issue.
I don't think so. Thank you, Ms. Cliff.
I did have one.
Okay.
What about, with respect to the drugging for sex, what about not administers, but caused to be
Causes to be taken?
causes to be taken?
The Commonwealth points out in their brief that the jury could have relied on that. I have two answers to that. One is I don't think that sharing alcohol and drugs is the same as causing somebody to take it. It seems to me that that's a more, which I think is what the appeals court says is a more forceful thing. The other problem is that if this court agrees that the appeals court was right when it concurred with the defendant's position that the instruction on administered to was incorrect, it doesn't really matter whether the evidence, in terms of a reversal, it doesn't matter whether or not the evidence was sufficient for causes
It
to
may
be
make a
taken,
difference
but it
as
would-
to whether retrial.
That's correct, Your Honor. It would certainly go to that. And with that, my response is what the appeals court had to say. All of these things, applies to administers, causes to be taken, involve some more forceful action than if you want to get a beer, there's one in the fridge, or yes, you can, I'll allow you to share my cocaine.
Thank you, Ms.
Thank
Cliff.
you.
Ms. Sullivan?
Good morning. May it please the court. Jane Sullivan for the Commonwealth in this case. I will address the defendant's first issue. The Commonwealth submits that the appeals court correctly ruled that an incapacitation instruction was required under the facts in this case. The only evidence about performing oral sex on the defendant occurred during cross-examination. It's in volume 2, page 255. And it was defense counsel who asked something about, whatever. So you agree you did perform some degree of oral sex on him. And the victim simply says yes. There's no follow-up. There's no further questions. There's no testimony that she did so voluntarily. There's just no elaboration on that. And the remainder of
Could you say it again? You agree? What did she say? What was the question?
The question was, it's on page 255 of volume 2. The victim agreed that she, and in the question was, did perform some degree of oral sex on him. And that was it. That was the only mention.
The word voluntarily wasn't in
No,
there?
the word voluntarily is not in there at all. And I suggest that that's not that she did so voluntarily is not a particularly fair inference from the evidence that was presented. The victim herself testified that she had had at least 13 beers, 4 to 5 glasses of wine, and numerous lines of cocaine. She testified that she was high, she was drunk, she was out of it. She didn't remember, and I would suggest that the most telling testimony occurs in volume 2, pages 212 to 213, where she winds up in the defendant's bed and she realizes that she's naked. She does not know how her clothes came to come off, but she is made aware of that she feels the defendant licking her vagina. At that point, she says no, tries to move away, and that's when the defendant says no, do another line. And she actually does do that. And she says she has no real memory. She's becomes aware again when she hears her friends outside the door, but she calls, or the friends call to the victim. There's testimony from the defense that the victim did respond in a normal voice, but she never came to the door. They had to ask for her repeatedly. They finally had to open the door themselves. They find her on the bed. She's trying to put her shirt on. The friends have to help her put the shirt on. The friends help her get up. They help her with her balance. There's testimony that she's unsteady on her feet. She doesn't have very good balance. There is testimony that she was slurring her words and that her mouth was moving in a weird way, but no words were coming out. They get her to the car. The victim does go, after talking with her father, the victim is taken to the police station. She testifies that she has no real memory of even being there. The officer who sees her there says that she's highly intoxicated, and it takes she's there for 45 minutes. She testifies that she doesn't think that she told him for anything, and he said that it was the information was slow in coming out, although he thought that she understood what he was saying. The next day, she goes back to the police station and speaks with another officer who basically sends her home because she's out of
Ms.
it,
Sullivan,
she's disoriented,
let me
incoherent.
ask you this. If the victim testified, as she did, that the defendant didn't force her to perform oral sex, what do we, because that she did testify to.
Well, I don't know that that's actually the testimony. I mean,
Well,
she
I've just got the
simply agreed-
question, and he didn't force you to do that, did he? No. That's the question and the answer. So, I
It
mean, what does
needs-
that mean? If he didn't force you to do it,
I don't think he physically, I think it means that he did not physically force her to do it, but that doesn't mean that she did so willingly. And in any event.
Or knowingly.
The resolution of the testimony is basically one for the jury, and that's what the judge said in the argument, the required finding arguments. It's like the defense was arguing inconsistencies in the testimony, and that those were particularly within the jury. And that's what essentially what the appeals court said, that even if that's true, if there is a suggestion that it was voluntary, that it doesn't negate the other evidence, and it was particularly within the jury's province to resolve those inconsistencies. And the judge properly instructed on incapacitation in conformity with Blaish or Blash, and the instructions did not have the infirmity. In Urban, he made clear that, the intoxication was equated with unconsciousness, helplessness, or mostly unconscious. And
Was
the
this tried,
instructions, I believe
when
it-
was this tried?
Excuse me?
When was this tried?
2005, I believe, so it was before Blaish. So the judge did not have to instruct about the defendant's reasonable belief, but I would suggest that the evidence was more than sufficient since it was the defendant with whom she was with the entire time who was providing the alcohol, and particularly the evidence on page 212, 213 of Volume 2, where she comes to, she tries to leave, and he says, no, do another line, and then it goes on from there. I would suggest
If
that
I
that
can
was-
turn you to the drugging for sexual intercourse, which we haven't
Yes, Your Honor.
discussed. Let me give you a hypothetical, all right? Let's imagine you've got two college kids before a football game, one male, one female. Both have not had sex, but both agree, let's get plowed on alcohol or drugs, and with the view that that will diminish our inhibitions and maybe we will allow things to happen that we wouldn't otherwise permit to happen if we were sober. Both sides get unbelievably drunk, and they have sex. Crime?
Under drugging for purposes of sexual
Right.
intercourse?
It's because it was given, the alcohol was given with the purpose of stupefying, overpowering, so as to enable that person to have sexual intercourse.
I believe that that is possible, that there could be a prosecution for that. And it would come up if the victim says, or comes forward and says that it wasn't consensual. Excuse me?
Who's the victim in that case?
The man or the woman?
Both, each.
It could-
No, I'm asking her. Who's the victim?
It could actually be both, or it could
Well, how
actually
do
be
we
both.
decide?
But all this, excuse me?
How do we decide?
Well, what the statute requires, I mean, you have to, it's giving with the purposes of stupefying or overpowering. It's with the purposes
They're
of
both- they're both-
basically facilitating rape.
Yeah, but they both go to the kid on the campus who they have told can get them easy access to fill in the blank, alcohol, marijuana, cocaine. Everybody knows that Jane over there, excuse me, I didn't mean because
That's right.
I was trying not to be gender, and so they go and, they're both there and, they acquire alcohol and they both sit down. Who's the giving?
Couldn't we resolve that if we put a gloss on the statute of adding that the statute really means somehow surreptitiously? If we put that gloss on it so that we don't get into that problem in this case, that that's what it means, that the administering is either purposeful or surreptitious, that would solve this problem and probably a lot of others.
No, I don't think that you need the gloss. I mean, I don't think that that's appropriate. I don't think that that's what the legislature intended.
So
there was
one of the differences between Justice Gantz's hypothetical, it's much less comfortable when they're both 18 years old, right? Then we start saying they're both victims and so on and so forth, correct?
Or it's both consensual, and I mean, it wouldn't come to light unless one of them was claiming
because
that
there's no question that they were both, I think Justice Gantz's hypothetical is that they were both close to incapacitated because they wouldn't do it if they were capacitated.
But in this case, I take it, he's the only one who can purchase the alcohol. She's not old enough. He does purchase it. He's the sole supplier of the cocaine. I mean, it's a very different situation.
This is a different situation. He is the one who actually is the supplier. He's the one that provides it, and he is the one who actually encourages her to take it. I mean, this particular situation is nothing like Judge Gantz's.
I mean, if you take Justice Gantz's suggestion, that would make half the population criminals. I mean, men and women get together every day and decide to get drunk or to do drugs or of one form or another, and I don't think that's what the legislature was intending to criminalize.
No, and that's
here
not
at
the way
all.
it's been applied. I mean,
Yeah.
as far as I can see, there's only been 2 cases in Massachusetts, decided opinions in Massachusetts, even dealing with this statute. One is Odell and one is Tatro. And in those cases, the appeals court said that the defendant had plied the young victims by simply giving them pills when they went to sleep and molesting them when they were asleep or, semi-unconscious. And the same in Tatro. It was the defendant gave the victim beer and other strong alcoholic drinks. So, I mean, I think it's telling that there are there are just a handful of published cases under this statute.
I don't know what that means because I don't know how many plea bargains there are. But I mean, leaving that aside, where did the word administer come from? Did somebody ask for it?
No, it's in the statute. The statute uses the terms whoever applies, administers, or causes to be taken.
No, but in this case, she was just, who was the judge?
It was Judge Agnes.
He was just using the words from the statute?
He was using the words of the statute, and there was discussion about what administer means, and the defense did say, no, it means more than just providing or giving. And Judge Agnes said, well, it could mean that, but it doesn't necessarily mean that you have to inject it or that it has to be given involuntarily. And so the judge said, no, I'm going to read from the statute, and I'm going to say to provide. And I would suggest that the appeals court is just simply wrong, that administer does include the concept of provide.
Well, let me ask you a different hypothetical. Let's say I have a party and I have an open bar, and several people come and they just drink and drink and drink, and they go off, and there's an allegation later on that there was a rape. Have I administered?
But there's another part to it. Even if you've administered, there's still another part to it. You have to administer with the specific intent to stupefy and overpower for the purposes of having sexual intercourse. So if your intent is to provide it, so to facilitate rape, then theoretically, I suppose there could be a prosecution under the statute. But the Commonwealth's position is that the gravamen of the crime is the criminal intent, and it's the intent to stupefy and overpower for purposes of sexual intercourse, and that's what this statute is getting at, and that's why it's a 10-year mandatory minimum.
But think about the word administer. Does a bartender administer drinks all night? Is that what we think about when we think
No,
in
and
terms of
that's
administer?
what
he
defense
doesn't
counsel-
administer it for the purpose of stupefying somebody to have intercourse.
Well, he
I mean,
doesn't
this
administer
is
it for
way
any
off-
purposes.
But this
I
is
mean,
way
that's-
off the mark.
But the statute doesn't simply say administer. It says or causes to be taken. And I suggest that in addition is to give.
The bartender, by serving drinks, causes them to be taken.
Well,
Just
the
wondering.
person still, right, exactly, yeah, he provides it, and then the person still has to ingest it. But there's nothing in the statute that says that the ingestion or whatever, the digestion needs to be involuntary, or that there's deceit or trickery or any other force involved when you have the specific intent to stupefy, overpower for purposes of sexual intercourse.
Do we have any legislative history as to whether this was focused on date rape drugs or anything else? I mean, isn't that the context?
No, I believe it's a very old statute. I think it was back in the 1800s. It was amended in 1998 to include unnatural sexual intercourse, and it changed the minimum term of imprisonment from 3 years to 10 years. And in the preamble, there was an emergency preamble with that, and it specifically says the purpose of this statute is to prevent drug-induced rape. And in addition, with the amendments to this statute, that amendment also added a statute, 265-26B, which is drugging for purposes of kidnapping. And so it's connected with an intent to rape.
But now you have this peculiarity that the sentencing here is actually more severe than for rape. It's 10 years to life.
It is.
So, and you're asking for a relatively broad interpretation of it that may include anybody who basically says, I want to give somebody alcohol with the intent of having sex with them later
You can-
on.
well,
I mean, I recognize they must be stupefied or overpowered, but that's a little bit less, that language is a little bit less than the language we use for the kind of rape without force that we're talking about here.
No, I think it means that you intend to have sex against their will or without their consent or knowing full well that they cannot consent. And that is rape under
You would
Massachusetts
add
law.
that clause to the stupefy and overpower language.
Well, I don't think you even have to add it as a gloss. I think it's right there. It's right there. The judge said that there were 3 elements. One is however it's given, or however the victim comes into it. But the other one is with the specific intent to stupefy or overpower, and for the purposes of having sexual intercourse. That's rape. It's with the specific intent to rape, I'd suggest. And that's within the language of the statute itself, without any gloss. Without saying that there has to be trickery, there has to be force. That is a culpable criminal intent to rape.
Which is not necessary for rape. I mean, you don't have to have a specific
No,
intent.
you don't have to have a specific, no, that's true, you want to think, you don't have to have a specific intent to rape. But here, it's very specific, and that's precisely the way the judge instructed the jury in this case. His focus was on the criminal intent, not how the victim came to become incapacitated or whatever, how she got contact with the alcohol and drug. But here we have evidence that it was, in fact, the defendant who procured and provided them to her, encouraged her to take them. When she tried to say no and to leave, he says, no, do another line, which she did, and then she doesn't remember. Things went on from there.
Would it make a difference in this case because she herself couldn't acquire the alcohol? Let's just leave drugs out of it for the moment. I mean, so both of them are participating in, on the drug side, in illegal substances. But if you had 2 50-year-olds, and again, I'm going back to Justice Gantz's hypothetical. If they both agree that they want to consume a large amount of alcohol, she or he, either one, can't hold their liquor as well as the other.
Yeah, I think you get hung up on the other 2 elements. I think you get hung up there in prosecution with the specific intent to stupefy, overpower, and for purposes of sexual intercourse. So you get tied up with a specific intent to rape. And if it's consensual between 2 people, whatever, I don't think you're there. I don't know
So
that you'd be there under the statute.
It's really the second element.
Yes, and so I would suggest that that is what's clear from the statute. And so based on the trial judge's interpretation of the statute and his instructions, I would suggest that the jury was properly instructed and that the defendant was properly convicted, the evidence was sufficient, and I would ask the court to affirm the defendant's convictions.
Thank you, Ms. Sullivan.